Hello and welcome to the Kenneth Vercammen Legal Podcast. In this edition, we look at some of the 2017 changes to estate planning, estate administration, and estate taxes. And one of the major things that happened effective January 1, 2017, is that New Jersey is making changes to the estate tax law. So effective January 1, someone can give up to $2 million without the state having to pay any estate tax. Previously, it was $675,000. So, and then effective January 1, 2018, the New Jersey estate tax is being repealed entirely. So that's very helpful for people that have substantial assets. And even before that, sometimes $675,000 was easy to achieve because the New Jersey estate tax law counts life insurance and a house. And it also includes any beneficiaries that transfer without the, not under a will, such as 401k, things like that. But however, one of the things that many people do forget, there was no change to the New Jersey inheritance tax law. So in New Jersey, there is an inheritance tax, and although there is no tax if money is to be inherited by spouse, children, grandchildren, there is a tax basically for every other human. So if someone is a brother or sister, there is first $25,000 is tax free. Afterwards is a tax at 11% up to $1 million. After that, the amount increases. If someone is not in those categories, then they get taxed 15% right away. There is no tax if monies are going to what we call bona fide charities, real churches, real nonprofits. Making donations to GoFundMe are not tax deductible. And there's other information on our website, njlaws.com, and our website, njwillsprobatelaw.com, on this. Now, for very rich people, there is still a federal estate tax. However, that is up to $4,449,000. So not a couple can do some type of estate planning so that they can gift up to $11 million without having any kind of tax. Point 4, even though there's typically not a New Jersey estate tax, we sometimes discuss with our clients the benefits of setting up a testamentary trust within the will. Most people say, okay, I love my wife, I love my kids, everything to my spouse, thereafter to my children. However, sometimes someone might say, I explain to the clients, because listen, if all that money goes to your spouse can go to Atlantic City and spend all of it. Or if they have to go into a nursing home, it's not protected. Or if your half that goes to your spouse can be attacked by creditors. But also there's the issue of a possible remarriage. And it's an ugly thought in a way, but people do get remarried. And if someone gets remarried, number one, if there's no will, the new spouse is entitled to 50% of the estate, even if they've been married for only 2 days. And also, if there's no prenuptial agreement, even if there is a will, a spouse can elect against the will to get up to 1/3 of the estate. So how do we protect the money that might go to the kids? Within a will, we do something called a testamentary trust. And what the testamentary trust says is that anything I own goes to my spouse, however, in a trust for the benefit of my spouse. The trustee will be one of the children or someone else that you trust, and the trustee can expend as much money as is needed for the health, education, maintenance, support of that child. And then upon the death, it goes to the children. So the children there are protected. And that also, if the money's in that trust, it's protected from Medicaid. Point 5, self-proving wills. Under the old law, there was a requirement that one of the witnesses appear before the surrogate's office to say, yeah, I was the witness to that will and I saw it, but they have to go to the surrogate's office and they had to sign paperwork. So there was, and my grandma, when she passed, it was under the old way, and we had to found one of the witnesses, and the lady goes, "Yeah, I'll go to the surrogate's office, but my fee's $500." So there was a change in the law some years ago to say that there can be a self-proving will, and that means the person signs, and there's two witnesses, and then the attorney or notary, then they sign some language again. Therefore, the the witness does have to go before the surrogate. The executor only needs to bring the original will, death certificate, check for $150, meet with the surrogate, and for most estates, that's all the surrogate needs to do. So that's, it's a good idea to do a self-proving will. This garbage that people do online is not a self-proving will, and then the witnesses will have to be discovered. And most of the people that cheap out and do things online do it wrong. Point 6. The new probate law made some changes, and one of the things where it's a possibility that a writing intended to be a will could be a will, but for many people that's not really helpful because it requires spending a lot of money filing a complaint, order show cause in a superior court. So someone conceivably could have wrote on a Christmas card, "I've just all my jewelry I want going to my daughter," and then sign it, and the daughter could change it. So anything that someone wants should be in the will, even if it's specific bequests. Point 7, the New Jersey Supreme Court last year again looked at what's called undue influence, and if someone breaches their fiduciary duty as an executor or co-trustee, they could also be liable for attorney's fees, and that was the case of Adrian Fulcher. However, a spouse, if they're not the executor, not the fiduciary, wasn't liable, even though they kind of transferred and mismanaged their spouse's assets. And the last couple points that we want to go over, powers of attorney. Don't rely upon garbage online, because a power of attorney a bank does not have to honor a power of attorney unless it references the New Jersey statute. And the stuff that people buy cheap out and get for online does not reference the New Jersey statute. Point 9, there's a federal HIPAA law. So the living wills that we did years ago, we want to revise to have language saying that under the federal HIPAA law, they've selected someone to be able to talk to doctors. Otherwise, doctors can't talk to people. And finally, a competency to sign a will. It's always important to avoid undue influence. The will shouldn't. It's best not to have family members as the witnesses and them doing the wills. It's best to have a disinterested, attorney and disinterested witnesses be the witness to the will. For more information on wills, the new New Jersey estate tax law, and other information on estate planning, go to website njlaws.com and also to the website njwillsprobatelaw.com. And for estate planning and other representation, contact the law office of Kenneth Vercammen in Edison at 732-572-0500. Thank you.